So hello, I'm Shubha Ghosh. I'm the first and thankfully not the last judicial fellow. So I've been working at the FJC on these issues of patent reform. And so people have seen phrases like frivolous patent litigation, patent trolls, non-practicing entities in the newspapers regarding the need for patent reform and companies that are just acquiring patents just for the purpose of suit. But I'm trying to put some numbers to it and looking at some data at the FJC. So one of the cures that Congress has proposed, and there's a House bill as well as a Senate bill, is trying to make it more costly to bring lawsuits by shifting attorney's fees and costs to the loser of litigation. The general rule in litigation now is that each side bears their costs. So one of the things that Congress is playing with is how do you try to have the loser make it more expensive for them to bring potentially frivolous lawsuits. So under current patent law, the law does allow for shifts of fees and costs, but only in exceptional cases. And so this law has been around since 1952, and the question is what counts as an exceptional case? So the proposed congressional reform, both in the House bill and the Senate bill, has lots of different measures. But with regarding attorney's fees, one of the things they're trying to do is shift fees automatically. So whenever you have a loser in a lawsuit, and the idea here is that, say, somebody who has a frivolous lawsuit that's losing, they automatically have to pay the costs, but it will only shift back in unexceptional cases. And so this is what's pending in front of Congress, but there have also been some important judicial reforms. The Supreme Court last year in a case called Octane Fitness versus Icon Health actually raised the standard or reversed the standard for exceptional cases. And so this gives us a way to actually look at data to see whether the rules for attorney's fees affect behavior. So that's the idea behind this project. I only have 1 year fellowship, but we have the potential to continue this project when I go back to the University of Wisconsin in the fall. But we've got 3 periods of time to look at cases, 1982 to 2004 and so on. And this isn't the slide, Eddie. That's fine, that's fine. I had another slide that had changed it. I did a little dry run of this on Tuesday. But I had another slide that showed you the increase in patent litigation over time. And what this slide is just showing you is data that I've collected on 285 motions. So I won't talk about it, but just trust me, they've gone up over time as well. So we've got a set of data that allows us to look at 3 time periods where there are changes in the law. And this is kind of a summary statistic about grant rates by courts for attorney's fees and whether they treat patentees different from non-patentees and so forth. And the basic statistical analysis that I've done for the data so far is to show there hasn't really been that much change in behavior with a change in the law in terms of how courts behave. And so part of this project is not only looking at it quantitatively, but also looking at it qualitatively in terms of how do courts determine whether to grant or deny things, and that's what that slide showed. And so the basic conclusion is that effective reform needs to guide judicial discretion more, that Congress has to really narrow or identify the set of cases where they really want to target, where they think spurious litigation or frivolous litigation is occurring. And just some of the changes that Congress is playing with just may not be sufficient. So if there's more information, you know how to contact me, and thanks again.